and thank you for joining us on our podcast today, Justice and Change for Victims of Nursing Facilities. And today on our podcast, we are welcoming Emily Hardy with the Virginia Poverty Law Center. And she is an elder attorney at the center. And we are just elated to have Emily on with us because Emily is coming with a lot of information that most of us probably didn't know. Services that are provided by the Virginia Poverty Law Center as it relates to our elderly. And that includes those of our elderly that are in nursing facilities or even at home care. Just services and things that are available to you through the Virginia Poverty Law Center that will be beneficial. So Emily, we welcome you. We thank you for coming and joining us today. And we have Tracy Pompey, Vice President of Justice and Change for Victims of Nursing Facilities. Tracy, if you'd like to just say hi. And
hello, everyone. And thank you, Emily, for joining us.
Thanks for having me.
Happy to be here today. So we're going to just go ahead and start with Emily. If you would like to give us just an idea, a broad view, and introduce us to the Virginia Poverty Law Center and their services.
Yeah, that would be great. As you said, I'm an elder law attorney, and prior to coming to VPLC, the Poverty Law Center, I have worked in the Medicaid field for a long time. So I think some of this information will be focused on Medicaid, but VPLC as a whole focuses on a lot of different areas of poverty. We're a nonprofit that primarily works on advocacy, so legislative advocacy and administrative advocacy. For legislative, that means trying to get laws changed that are not beneficial to people in poverty, trying to break the cycle of poverty so that people that are in poverty are able to get out of it. And that's kind of a variety of areas. It's not just elder law, it's across the spectrum of poverty issues. And then when we talk about administrative advocacy, within my role, it's primarily focused on things like Medicaid program, Social Security, Medicare, things like that, that have a governmental agency that runs a program that people have to apply for, access, and then sometimes will end up, being denied care or receiving penalties for reasons that involve programmatic roles. So what we try to do is make it so that bureaucratic processes and those kinds of programs are able to be fixed if they're stopping people from accessing benefits incorrectly, and try to advocate that we change those types of processes so they're easier for people to access. In the broader scope of VPLC, we do work in healthcare, like I said, so that's part of my work, as well as elder law generally, domestic violence, housing assistance, utility assistance, child welfare, economic issues, so trying to get rid of types of debt that are predatory towards people, assisting with utility issues where somebody's getting shut-offs. It's kind of a really broad range of work that we do across the legislative and administrative advocacy sector. We do less direct services, which is sort of, I guess, a term of art for legal aid, is meaning that we don't take as many individual cases to represent somebody. So that's something legal aid will do generally. And we might assist them with helping research an issue or evaluate a case that comes in, but we wouldn't be the attorney on the case. So it's kind of a different model. We're not really representing individual people. We're trying to change the systems that people have to interact with, whether that's administratively. And in some circumstances, we'll do things like class actions where it's helping a broader group of people, and we might do that in conjunction with other legal aids. But most of the time, we're not going to take an individual case and go to court with you, although we may have a helpline where you can call in and get some limited advice, even if we can't take you to court. So we have eviction helpline, a utility helpline, elder law helpline as well. So if you are over 60 and you need some advice, and sometimes that advice is just, yes, you do need an attorney, you need to call one immediately. Or maybe the advice is, no, I know this sounds really scary, but this is not going to be a problem. Here's the reason. So it's kind of a first step for someone to try to figure out if there's merit to the legal issue they're dealing with. So that's a lot of information probably about what we do, but like I said, it's a broad range of things. both for people over 60 and then for people of all ages who are in poverty.
I'm glad you drew the difference between the Virginia Poverty Law Center and the actual legal aid. I think that's good. I like that. That's because initially I thought that it was all under one, collective. So I'm glad you drew that point out.
Yeah, we try to work really closely in conjunction with them. So we have a lot of like joint task forces where we'll provide assistance, or they need a resource of some kind and we try to meet that need. But they are the ones that are primarily doing all of the direct services in Virginia.
Okay.
Going to court.
Okay. So, okay, just for the premise of this whole podcast, it's more relaxed. It's not, so if you have a question, Tracy, just go ahead and interact, and we're just going to go ahead like, we're discussing it.
Yeah.
And one of the things I wanted to ask, the services for those over 60, do they come to you directly for that, or do they have to go through legal aid to get to you? They can go directly to the Virginia Poverty Law Center to inquire?
So we have a senior helpline. So if you have an issue that fits within the senior helpline, you can call that number directly, and that will be run by an elder law attorney that works for us, Sarah Morton. And so she currently runs that helpline, and it covers a variety of elder law issues. So if you have a Medicaid question, guardianship question, a question about age discrimination, kind of a variety of issues that have been identified by funders as being specific to older adults. You can call that helpline directly for brief advice and services. As far as the majority of my work is not going to be individual people that I'm working with unless they are related to like a specific advocacy push that we're doing. So if we are trying to change a law in a certain area and you individually have been impacted by that and want to be able to tell your story or talk to us, provide information to legislators, that's definitely something that individuals can contact me about. But if they're looking for, I have a legal issue, I want help with it, either legal aid is the correct place or the senior helpline if they just want to know kind of, is there merit in this? Can I do something with it? What's happening? The helpline can assist in certain circumstances. And where it can't, it should help redirect somebody to another resource.
Okay.
Well, Emily, I'm sorry. I was just wondering, Emily, I know it's for people that are low income poverty, but is there a range as far as income for people that y'all help?
Yeah, so unlike legal aid, we don't have restrictions on income for brief services. The issue is that if you have something that is related to having a lot of money, we just might not have the expertise because it's just not something that we focus on. So, you wouldn't go to a heart doctor for a liver transplant. You probably wouldn't go to a legal aid for something that's has a ton of money because it's not, those aren't the issues our clients have. So that's not what we're focused on. He has higher levels of income. We don't have a strict cutoff. It's just it's more the topic areas that it wouldn't be something we would be the best suited to help with because we're not experts in it.
Okay.
But yeah, we do not have like you're above this income, we will not speak with you. Which legal aid is required to have some of that because of their funding sources. So the federal government, if they get grants or other grant providers can put in restrictions, you can only speak to people in this income range. We don't have that in general. And I think if somebody has an older adult grant, meaning from the federal government, there's the Older Americans Act in legal aid, sometimes those are more generous than other grants. So even though you're a little bit above, you might qualify if they have that specific grant. So it's really hard to say which legal aid can talk to you or not without you directly reaching out to them. But if they aren't able to assist you and you still think you need at least some brief legal advice, you can contact us and we can evaluate if it's with or help you figure out where to go to try to get help.
Okay, so it is like very much service oriented in terms of if you don't know, you can still call in and ask and you can still point in the right direction or offer whatever direction you can, irregardless.
Yeah, we try to. I mean, if it's something that we genuinely have no idea and doesn't relate to poverty, what we might say is that the Virginia State Bar has a $35 helpline. So if you call into the Virginia State Bar, you get a half-hour consultation with an attorney for $35. So that's a pretty low cost compared to standard attorney fees, which can be like $200, $300 an hour. I don't know. I've never done that. I've always worked in poverty law issues, but I know that they can be expensive. Also, the ABA has a Virginia Free Legal Answers website. And so if you type in a legal question there, you can get an answer for free from them as well. So if we're not able to help, those are kind of two big resources that exist that are not high cost as a starting point for someone that they can always call and try to get help through those as well.
So what do you look for, like when, you know, a Medicaid, when it comes to Medicaid in terms of, I don't want to use the word qualifying, but the financial position as far as Medicaid is concerned? How,
Yes.
Go ahead, sorry.
Sorry, I think there's a delay on my internet, so I'm sorry if I speak over you.
That's okay.
Thinking of it as like eligibility qualifications. So there's 3 broad categories that you have to be eligible in. There's non-financial eligibility, income eligibility, and then resource eligibility.
Mm-hmm.
So non-financial are things like, what is your legal presence in the US? Are you a resident of Virginia? So you do not have to be a citizen to get Medicaid. If you are legally residing, meaning you have a certain status, you're a refugee, you have a green card, things like that, you could be eligible for Medicaid depending on your specific status. And it's so complicated that I don't think we can go into it, but it's not an automatic bar. I think sometimes people think that, you know, if you are not a citizen, you cannot get Medicaid under any circumstance, and that's not true. For some statuses, you have to be here 5 years before you can get Medicaid, so you can't get it immediately. But then other things like refugee statuses, or if there's an emergency situation, you might be eligible immediately. So it's complicated, and if somebody has an immigration status and thinks that they're incorrectly being denied, they can call in and we can try to help them figure out if it's being done correctly. And then, like I said, you have to legally reside in Virginia. So if you live somewhere else, you have to get Medicaid in that state, not in Virginia. And then you would have to follow the rules of that state, not Virginia's Medicaid program. Emergency Medicaid exists, like I said, for certain people who aren't otherwise qualified. And if you're legally residing but not qualified for Medicaid, you might be eligible for marketplace insurance. So it's kind of all interconnected. There's some backup systems, but there are some people who still fall through the cracks in our healthcare system, unfortunately.
Yeah.
Especially with long-term care. If you're, you know, been here less than 5 years and you need long-term care, there isn't really another payment source that exists to cover that gap here in the US. So there are, like I said, some backup systems, and then in some ways there really isn't a better protection for certain people. And then the other kind of big non-financial need for long-term care is you actually have to need the long-term care, which seems obvious, but Virginia has a system to evaluate that. So you have to be at risk of institutionalization. You have to be dependent or semi-dependent in activities of daily living. And probably a lot of people are familiar with ADLs, but if you're not, that's things like I need help bathing, I need help eating, I need help grooming myself, dressing, all of those sort of things that let you get through a day. But all of us get through the day on our own. If you need help in those things, you have to meet a certain level of help before you can qualify for nursing home or home care. And Medicaid categorizes them together as long-term services and supports. So LTSS is the abbreviation they use for that. And they have very similar rules between the two programs to be eligible. So if you're eligible for nursing home care, you would be eligible for home care, and you're supposed to be provided the option of which you would prefer. Obviously, practically speaking, that doesn't always work out.
Yeah, I was just going to actually ask you about that, because when you say you're supposed to be provided, the word option often doesn't happen as an option. You know, it's often a predetermined, this is what you need. And if you don't do that, then particularly if you're not going into a nursing facility, then you will only qualify for 25 hours of home care, which is, you know, it's crazy. You know, and I think it forces a lot of it forces a lot of people away from home care because they can't 25 hours. I know that was my experience. and my mom needed, round the clock care, but it wasn't presented as an option. So is that something like, how do you guys work with social services when it comes to things like that?
So if you're ordered less care than what you actually need, you can appeal that decision and argue kind of category by category why the hours they provided are incorrect.
Mhm.
So, they say that I need 1 hour a week of grooming, but this is how long it actually takes me and the amount of assistance I need. It's the way it's currently set up, I don't think it ever gets to around the clock care, but it can get to a significantly more than 25 hours a week. And there are some things like supervisory hours where somebody needs assistance overnight because it would be unsafe for them to be in the home alone, which can be added on. You would just have to show proof of that. It gets complicated because if you're a family member who lives in the home with them, there's sort of a presumption that
Mhm.
they only need supervision when you're not there. So you would have to show proof that, if it weren't for this need, you wouldn't be there, or you would have another job, or, there's some reason why you're not providing this for free because economically you can't. So some of those arguments get complicated, which would be a good time to talk to legal aid if you're able to access services so they can help you evaluate if this is, if they accurately assessed all of your parents or family members' care needs, if when they calculated it out, it was done correctly. They have some formulas that you can kind of walk through. And then in part, it's just talking through and providing evidence of what the actual length of time is needed. And then when you appealed it, you would go in front of a hearing officer and you would get to present all of that evidence to the hearing officer. And,
So
oh, sorry.
no, I'm sorry. I was just gonna say, so I just find it strange that there's no taking in consideration of when a family member has to make that decision to do that. As far as like, okay, I have to quit my job because, like say,
Can't get enough
25
hours.
hours.
Yeah.
And so you have to, if you have a full-time job, well, now you have to find a way, you have to quit your job. Like for me, I'm an only child. So what I'm saying, if for someone who wouldn't necessarily have the support there,
Mm-hmm.
things like that are not considered.
I think that they should be, but I agree with you that
Yeah,
sometimes they are
exactly.
not. Yeah.
Mhm.
So
But then there's a formula, like you said, that they have, right? They use a specific formula to determine these things.
they have like a breakdown by category of activities of daily living that you need and how much assistance you need in each of them, depending on your answers to the questions when you're doing the original assessment. So they do an assessment like a UAI, Universal Assessment Instrument. I love when I try to say out the title of acronyms, I may have them slightly incorrect because I primarily use acronyms.
Mm-hmm.
But they do an assessment with you to say, in food preparation, you're semi-dependent because you can microwave food yourself, but you need assistance cutting it up. So if you eat, and I don't have all of these bits and pieces memorized to kind of go through the formula with you, but that's what I mean by formula is that they have it broken down into categories of things you need, and they have some standards amount of time that these various things take. But if for some reason, due to your specific circumstances, it takes longer, that is something you can argue at a hearing to a hearing officer and present evidence on to show that, okay, sure, the standard is this, but I have these additional medical concerns, which means that it always takes me an extra hour to do that activity. And so putting it at the standard amount doesn't actually meet my care needs because of my disability.
Mm-hmm.
And the other thing to remember is that the Americans with Disability Act always exists and can impact any programmatic role that is being implemented in Medicaid, meaning that my specific disability means that I have a higher level of need than someone else. I can ask that there's an accommodation made and that they change a policy so that I can access the program because I have this additional care need. So those are sort of legal tools to help where the standard program doesn't meet an individual's care need. But I completely agree with what both of you are saying, that the program itself doesn't always serve everyone correctly, and that it doesn't take into account family relationships in a way where it's not supposed to require somebody to provide free care, but sometimes the practicality of how it works and and the way it doesn't take into consideration everyone's needs adequately will lead to, you know, this sort of non-required, required free care. So I completely agree with what you guys are saying, that there needs to be more reform in the program. Some of these changes have to be federal. I know there's been some evaluation of the program federally. There's been attempts to try to fix this and make home care the standard and nursing home the exception. But I think those are kind of the long-term goals, is to make home care a more robust program so that it actually meets people's needs, because it costs less for someone to stay in their home, as well as, you know, lets them stay with near family and friends,
Right.
avoids, as the last few years have shown us, cross-contamination of illnesses and exacerbation of people's symptoms and things like that. So yeah, I agree with both of you. I don't think what either of you are saying is wrong, but you do have the right to appeal and make the arguments to a hearing officer for why your individual case means that there should be more hours.
And this is something that people can call into the Virginia Poverty Law Center and get this kind of advice.
Yes.
On this, based on what they present. And
right.
So you guys, like, use the Virginia Poverty Law Center to your benefit, to get the trusted legal advice on exactly what will address your issue, your specific issue, instead of a blanket thing that you may read or hear about. And so, yeah, that's really great. I guess you guys do work closely with social services in this regard, and that in itself is a whole other topic.
I think we often work more with the state level social services versus the locals. So Virginia has kind of a weird setup where our state and locals are separate. And so we are often looking at, across the entire state, this law is being implemented poorly, or it's not following federal law. Can you change the policy manual so the entire state has to follow this? And we do less individual casework with each DSS. That would be more the legal aid. The legal aids would have more direct interaction with the locals than us.
Okay.
Not to say that we don't sometimes have to, you know, reach out to an individual local aid, but we're more at the whole state level. So, but talking about the local DSSs and the difference between all of them and the ways that they operate could take an entire probably day. So
yeah. And what about the ombudsman office? How do you work with the ombudsman's office?
So
because they're also the go-to in the middle of a situation.
Yeah, so we try to work really closely with them. So if they have a legal question for a client, we try to make sure to always answer it and get them. So even if we're not talking to the client directly and the ombudsman reaches out to say, we have a situation, these are the facts, is there a good reason to appeal in this case? Or, you know, a nursing home discharge, do you think the client can fight this discharge? We would provide information to the ombudsman on kind of what the client could do and what we think the situation warrants. So we try to work really closely with them as far as like supporting what they're helping people with. Obviously, there aren't enough ombudsmen to adequately meet everybody's needs, but I know that they try really hard to make sure that they are client-centered. So doing what the individual in the facility or in the home care program wants, which can sometimes be, I know that can sometimes cause conflict, because if you as a family member thinks one thing is what should happen, but the individual in the facility wants something else, the ombudsman is going to go with what the person in the facility wants, because that's their client. And so I know that model can be kind of confusing to family members, but that's how they're set up, is to be an advocate for that individual. Now, if that individual clearly doesn't understand what's going on and lacks capacity, that could be an exception. But if they know what's going on and they want something specific and you want something different for them, the ombudsman may not be the best resource for you, because they're going to go with what that individual wants.
Okay.
And I can transition back into the other Medicaid eligibility rules if you want.
Yes.
I know I went on forever about the home care requirements and sort of the access to nursing home and the fact that you need certain care levels, but across all of Medicaid, you have to meet income rules as well as those non-financial rules. And so for long-term care, there's a couple of different categories. Two of the categories are primarily the same, with one having a couple of additional benefits. And that's if your income is under 80% of the federal poverty line, you get to follow SSI rules for asset review. Because Virginia, when we opted into Medicaid in the 70s, we did sort of an alternative route that only 7 states did. And so we have some criteria that's more restrictive than SSI. So it's harder to qualify here than it might be in a different state. So the 80% group, so if you have that low of income, you get to qualify with SSI rules, which are less restrictive. So they're more generous.
Mm-hmm.
For long-term care, if you're under 300% of the federal poverty line, you are primarily going to have the same rules as SSI, but a couple that are a little bit different. And then we have kind of a third main category of medically needy, and that's where your income is above the 300%. And I know saying 300% is sort of, what does that mean? But it's because it changes every year. SSI's amount isn't static. So every year it goes up. And I thought I had written down the exact amount that it currently is. Yeah, so it's in 2023, 300% of SSI is $2,742. So if you have income above that, you end up in a medically needy category for Medicaid. And what that means is that you have to accumulate medical bills to meet a spend down before you're eligible for Medicaid to pay the rest of your care for a month. And so it's sort of complicated, but it means that there is not as much of a strict cutoff for Medicaid for long-term care as there might be for other programs, because you could qualify medically needy with a spend down. And once you met your spend, and if you're in long-term care or home care, you have very high medical bills every month, right? Because those are very expensive programs. And so you would most likely meet your spend down for a given month and then have to figure out your patient pay amount. And that would be done kind of the same way as patient pay for any other program. But the difference is you are not counted as receiving Medicaid and medically needy until you have bills that bring you down to the allowable amount, like under 300% SSI. Or sorry, until you spend down kind of your excess income every month. So it's complicated and weird, but just know that there is the ability for Medicaid to pay, even if you're above that $2,700 income amount, because we have a medically needy program. And then you would just have to kind of meet the spend down requirement, which if you're in long-term care is easier to do because of expensive nursing home, expensive home care. And so then regardless of what program you're in, after you've met spend down, if you're eligible, or if you're just eligible immediately because you're under 300% SSI, they have to calculate your monthly patient pay to determine what portion of your income is owed to the facility every month. So Medicaid will pay the difference between what they view as your available income for payment and the cost of care that they've authorized for that facility. And so patient pay is taking your available income as calculated by Medicaid and subtracting out deductions. There's some common deductions, like if you have a spouse in the community who doesn't receive Medicaid, there's spousal impoverishment deduction. You can have a personal needs allowance, which is very minimal. In a facility, it's only $40 a month. But in the community, it's, I think, around $1,500 in 2023. And that is to pay for your mortgage, your car payments, your food, etc. So it's not a lot of money when you kind of account for costs of somebody living in the community. But it is much higher than nursing home. And then also, if you have a dependent child or family member that you're legally responsible for, there can be deductions for them to have a certain amount of money to live on each month, as well as in certain circumstances, you can deduct a cost to continue your house payments. So if you're going to be returning home, or if you have a dependent child that lives in a home, there's certain circumstances where you can take some money from your income and pay that towards maintaining that house. Once they take your income, subtract out the allowable deductions you qualify for, the remaining amount is what you owe the nursing home every month for your portion of the nursing home cost. And then Medicaid would pay the difference between that and the Medicaid rate at the facility. So it's complicated. And if you get through all of it and you come out the other side and think this, it doesn't look accurate, there's no way this is what it costs, you can appeal that and reach out to legal aid to see if they can assist you and evaluate your case and help you figure out if it is done correctly or not. Like I said, the big one is community spousal impoverishment. If you have a community spouse, they're allowed to keep a significant portion of income every month of your joint income. So let's say they have income of their own of $1,000. They could keep between around $1,300 of your dollars to $1,700 or so. Or actually, I think it's a little bit higher than that. Like, so I'm trying to do math on the fly, and that's never my skill set. But let's say $1,500 or so of your money, plus the 1,000 initially. So yeah, they can keep between $2,288 total and a maximum of $3,715 of income per month from joint income. So they don't get that in addition to what they own, but they could get up to that total, and the individual in the facility could pay them that month the amount, almost like maintenance in a divorce case or something like that, where you get that monthly check or child. Sorry, I've forgotten all of the true court terms, but if you're getting paid monthly to take care of somebody, Medicaid includes that type of spousal allowance calculation to allow somebody living in the community to keep more of the income so that they can maintain their house, they can maintain their lifestyle, they can pay for their food, their needs. And if the 3715, which includes your care, so if your house costs more than the average person, you can get excess shelter assistance, which can bring it up to the 3715. If that's still not enough for you to maintain your life, you have the right to appeal that and present evidence of why you individually need additional funds from the person in the facility to be able to meet your needs. That could be if you have really high medical costs yourself, or you have to take care of a child with severe disabilities, or there's another reason why the 3715 is not sufficient for you individually. But that's never going to be granted until you've gone to a hearing. So if that's something you're arguing, you always have to appeal it. So
with all that said, who actually makes the determination? Is this something that resident or family members sit and discuss with Medicaid, or is this just they make the determination, they put it on paper, and then they tell you this is what it is, and then you get to appeal that if you don't agree? Is that
yes? Yeah, they would make the determination. You would have to send in proof of your income and assets. They would evaluate them based on Medicaid's rules, and then they would send you a notice telling you what the patient pay amount was. And if you thought that was incorrect, you would have to appeal that notice saying that they've done the calculations wrong, or you kind of meet this need for additional payment for, you have the excess shelter, or you have another reason why this is insufficient. And so Virginia used to have a Medicaid appeal system where you couldn't really present additional information later on. It was very much, did you give it to everyone immediately? And if not, you have to file a new application. But our hearings have changed. And so now it's something called de novo, which means from the beginning. And so when you do appeal hearing for Medicaid, you can continue to present, additional information, because often people don't know what they should have presented immediately.
Right. Exactly.
And maybe they've had that evidence the whole time, but they didn't know Medicaid would need it. So there isn't a cutoff, like up through the hearing, you can present that evidence to the hearing officer to show why you have these additional needs that require additional income. And then the hearing officer may or may not agree with you. Like all hearing officers and judges, you present the evidence and make your case, and then they evaluate it based on federal rules and determine if they agree with you or not. So it's, doing a hearing doesn't mean you'll automatically win, but it puts you in front of a decision maker who gets to look at the entirety of the case, take your evidence into consideration, and then see if they agree with you, or if maybe they'll even grant partially what you're asking for, but not the entirety of it. So
it's something that the Virginia Public Law Center can help somebody strategize if they want to appeal.
We can help kind of review if you should spend more time on the case. The issue with it is that sometimes these cases require getting all of the documents and reviewing all of the documents. And so it may be that it's not really a brief advice, but really somebody has to intensely read through everything to figure out if there's a case. So it's going to depend on the individual facts of the case, whether or not calling into a helpline would be able to really evaluate it. But if you start telling us a story and we're like, well, this is really complicated, someone needs to like dig through all of your records, we would be able to tell you, you know, we can't tell sort of at the surface level whether you have a good case or not. We think you need to call legal aid because they're going to be able to, you know, better help you if you qualify for services than we could, or the ombudsman, or whoever else.
Can I ask you so this whole process, how long on average does it take when a client comes to you and has to go through all of this, even including the appeals? How long do they have to expect that this would actually take, this whole process?
Well, if they're calling us for help, we try to return calls as quickly as possible. So it depends on kind of the call volume for returning calls from us, because we have one primary attorney who works the helpline at this time. And so if, you know, you call on a day when 45 other people call, it might be a slightly longer delay to get back to you. But if we have the capacity and time, you know, our goal is to try to return calls within 48 hours where possible. As far as the appeal timeline, it is partially dependent on sort of the facts of your case, because you can ask for continuances. So if they say like, I need this document while the appeal is going on, you might be able to get additional time to request that and submit it. But if you're not asking for any additional time from the date you file an appeal, the decision is supposed to be issued within 90 days.
Mhm.
So it's like 3 months maximum, and that's going to include, you know, maybe setting the hearing at day 45, and then they have, you know, a month or so to evaluate the facts, write up a hearing decision, and then mail it out. And they have to get it reviewed by somebody higher up, approved, and then sent out to you. So the standard time is 90 days from the date of appeal.
Okay.
There's also a complicating factor that if you are appealing something with your managed care organization rather than Medicaid directly, you have to do an appeal with them first. And then once they issue a decision, you have to appeal it to Medicaid state fair hearings. And so that's going to be more like the issue you said with the 25 hours of care. That's going to be an MCO decision. Whereas these eligibility determinations like income and assets are often directly with the state. So it depends on the type of appeal, and the MCOs have a longer delay process because you have more stages where you can make your arguments at. So you appeal to the MCO, you do a hearing with them, and then you appeal to the state and you can do another hearing with them. And then, you know, if that decision doesn't come out in your favor, you have the right to bring it to court to argue in front of a judge that the hearing officer did the wrong thing. So there's a lot of stages of review where you can keep making arguments.
So how many times can a client appeal?
So you would do like one appeal per issue.
Okay.
So if you get a notice and you can appeal that individual notice. If they correct it and send you a new notice with a new appeal and you still think what they corrected isn't quite right, you have a right to appeal that new notice with that new appeal. Okay. If you make a request and they don't take an action on it, you can appeal that inaction. So it's sort of like each individual decision they make has its own appeal rights, but you can't appeal the same decision over and over again to raise it up to the next level. So the hearing officer decides against you, you would have to bring that same case to court. But if you try to bring it to the hearing officer again, they would say, I've already decided this. Like, this is, you know, your duplicate court case. We can't hear it again. So you, in that circumstance, you have to take it to the court to try to get an additional review of that issue.
I'm hearing everything, and I'm remembering how it was walking through a similar process with my mom and Medicaid and the application process. And I remember the social worker saying, we are not going to, the maximum anybody can get is 42 hours in a week. And even if you appeal, you're not going to get more than that. Is that a fact? Because I feel as though then you're not looking at the individual, or they're not looking at the individual cases per se, but they're saying, okay, this is the ceiling. Let's just see how close we can get to the ceiling. But I mean, I would have thought that they would consider, like Tracy was saying, they don't consider some things, but that being an individual case, because they do have protocols, they do have forms and questions they want you to answer, doctor's notes and records that you have to provide. So you would think that those things would be not hitting a ceiling, but if somebody needs like 60 hours
So
and
I pulled up the statute really quickly because I there's so many complicated Medicaid programs that I sometimes forget the exact like criteria of each individual one.
Mhm.
But I think the actual current maximum is 56 hours a week unless you meet exceptions, which are essentially like you have very, very high care needs. Uh, so it is 56 hours a week, but there are exceptions.
But see, then now, so then when you say very, very high care, then that's subjective, isn't it? Because then who's determining very, very high care? Very high care to someone who is working, the only breadwinner in the family, and they have a parent who is needing to be fed, toileted, et cetera, et cetera. That's very high care for them because they're the only breadwinner in the family. And I know that there are complications, I mean, you know, complicated avenues that can be taken, but it's just, I guess, how they're considered in terms of the reality of the situation in that home as compared to the protocols that are on paper.
So it does set out the criteria for very high needs. So it's not just like you have very high needs and you know there's no rules around it. There are criteria related to your activities of daily living and what your ADLs are.
Mhm.
And so there is a section of code that kind of goes through all of those. But I agree with you that there is always an element of subjectivity to some of these decisions because you have an individual caseworker doing the assessment. One of the things that we often see with our clients is that rather than telling somebody how hard it is to do all of these activities in the same day, they'll kind of consider each activity of daily living. If on my best day, yeah, I could do that on my best day. And so one of the things we always say is that if you're appealing this and you're explaining it, you have to consider that they're saying that you're doing all of these in a single day. And how can you do them on a medium day? How can you do them on a bad day? You have to be honest and present that information, which I think a lot of people are embarrassed to say what they struggle with. It's really hard to tell somebody those things. So
Right.
That's one thing that I really think matters in these appeals is making sure that you're not talking about sort of a hypothetical best day that hasn't
Yeah.
happened in 3 years. You're talking about
Yeah.
what could I do today? What could I do tomorrow? Like if I had to do all these things myself, like how would I be able to do them realistically?
Exactly.
And if I had a bad day, how hard would it be for me to do these things? So some of that's really important when you're talking to a person to like give them accurate information because they also can only go off of what you've
you're telling
provided
them.
them. So if you've told them that, oh yeah, I could do that. But to you could is like once every 100 days I could do that. That's not being able to do that,
Yeah.
right?
Yeah, right. Exactly.
That's like an exceptional, your arthritis isn't as bad or whatever else the individual person's issues are. So I think some of that's really important in getting rid of the subjectivity is just to be very specific and honest about what is hard to do and why it's hard, versus sort of the way we all want to present the best versions of ourselves that doesn't actually help you get services because they're going to take you at your word and they're not going to ask you the follow-up that maybe I, as your attorney, would ask you, being like, okay, well, what does could
Exactly.
mean? Like I, as your attorney, as your advocate, will ask you additional questions, but the caseworker is just going to take what you're saying as fact and not try to get you more hours. That's not their
Exactly.
role. And also, they
Exactly.
probably don't really have the time to delve into that if you're not giving it to them straight. Like they're not, that's not their job.
And I think it's very important because some people are afraid, like you said, to show their true self in that instance when they're dealing with a health issue. And like you said, it's very important to be honest about what your health is.
And you have the right to ask for somebody else to be in these meetings with you. So if you are embarrassed to do this, but a family member or a child will be able to be like, mom, like tell them about this, then it's good to invite an advocate in with you so that you're giving correct information.
Yeah.
One thing I think we're flying past this discussion here is that in the middle of all this happening, if you have a parent or somebody who's really not lucid, and not lucid in terms of that dementia or even mild dementia, who may not be able to accurately answer these questions, but may appear as though they know what they're saying.
Mm-hmm.
Is that a consideration? I mean, I think it's a major thing.
It is. I
Because
think so.
when you're sitting talking to this elderly person who appears to be fully, with it, but then at the same time, you're their child or family member, you know them well enough. And if they're saying, oh yeah, I can go up those stairs on a good day. We're looking at 13 stairs and a myriad of different issues that could, develop because they have certain things going on with them, and they may not be able to remember when they take 3 stairs that there's a fourth one that you need to take, and that at the reality. So when you're sitting there and you're saying, well, like you said, mom, remember when, blah, 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 will they take your word over the resident's word or the patient's word? Will they take your word? Will they say, well, your daughter said that you can't, do this and so on like that. Oh, sure, I can. I can do that. She's not
Yeah.
with me all the time.
That I think that is a great point, and because some seniors will do that. So that is a great point.
So I think one of the things as the child is to explain kind of the reasons why you're being honest in the situation, and explain that, if we give incorrect information, you will get less services. And so you will have less care, and it may mean that you need to go into nursing homes. So we have to make sure, even when it's uncomfortable, to tell them the truth. Because I had to counsel a lot of clients on this, and you just really have to stress that, you have a right to these services if you need them. And so you need to present information so it can be accurately assessed whether you need it or not. So we have to be honest and accurate about it so that they can understand what's going on. Additionally, where you have capacity issues, if you can present, a social worker's letter, a doctor's letter, other evidence that there's confusion, and ask, can I speak with you independently? I know my mom's going to say certain things. I don't want to upset her if that's a concern. Like if, disagreeing with her is going to cause her to get really upset. You can present that information to the caseworker and ask to provide additional information without her presence, and provide a doctor's note of support of what her capacity and limitations are, provide other evidence of these things that support your position. So it's not like you just have your word versus theirs. You can also have documentation and explanations of why, what she's saying isn't accurate, as well as if it's a person where you can reason with them and explain, just setting kind of the expectations of what the purpose of this evaluation is. And then if you're not honest, you will end up with less services because they're going to go off what you say. And so if that's not what's actually happening on a bad day, then you're not going to get as much hours as you need.
Okay.
And then I like how I love answering you guys' questions, so I want to make sure
we're taking you, we're taking you off the train track for a minute. Okay, go ahead, Emily.
So we could return to sort of the last Medicaid criteria, which is resources. So we had the non-financial factors, like, are you a resident? Do you qualify for care needs? We had the income factors of what category do you fit into? Do you have a spend down? How do you calculate your patient pay? Do you have spousal impoverishment? And then the final category is, do you have too many resources for Medicaid to pay such that you have to spend your resources down to get coverage? And so the standard resource amount is very low, and it's exempt assets aren't counted. So there are certain assets that they say you can keep this and we're not going to evaluate it. But of non-exempt assets, you're only allowed to keep 2,000. So it's a very, very low amount.
Wow.
The exception is, again, for community spouses. So where there's a community spouse, the individual in long-term care, either in home care or in the nursing home can transfer to the community spouse between a minimum of $29,000 and a maximum of $148,000. And it's kind of, Virginia has a weird schema for calculating the spousal resource assessment, but essentially the community spouse gets half of all assets. But if half of the assets is below that $29,000, then they get $29,724.
Which is the, yeah, okay.
But so if you have, $300,000 of joint assets between you and your spouse, you get to keep that $148,620. And then the remaining assets would have to be spent on medical care and other things before the person became eligible for Medicaid. So they could spend it on their monthly nursing home bill, which, as you guys, as everyone listening knows, will go very fast because nursing homes are not cheap. So that's what's kind of reducing your resources, is spending them on things like your nursing home care, hearing aids, anything for you yourself, the individual, and the spouse. You could go on a vacation together. There's kind of a wide variety of reasons before you're eligible for Medicaid of what you can spend your money on. What you cannot do is give it away for free, because there's a 5-year look back in long-term care Medicaid, which says that if you took an asset you owned and gave it to someone who's not your spouse, or in certain circumstances, a dependent disabled child, there's going to be a penalty assessed for the value of that asset. So if you have a car and you know you have to go into a nursing home, the month ahead of time, you can't give it to your kids. You would have to sell it for fair market value. If you gave it away, they would say, well, that car was worth $4,000, so you have a $4,000 penalty for transferring an asset to become eligible. It came about because people used to get rid of their assets to get Medicaid. So they would go through and dump all of their assets so that they got down to this $2,000 amount, and they might have, a really significant amount of money to start with. And so we have really complicated and difficult rules because of that was happening. So the response was to kind of create this 5-year look back and say, if you had a severe health condition where you realized you needed medical care, you could not give assets away once you knew that you might need this soon. So one exception is, let's say you gave your car to your kids a year ago, and then a month later you had a very severe disabling stroke. And prior to that, you did not need nursing home care because you were completely independent and had no issues. That could be an argument to say, okay, yes, I gave the car away, but I didn't give it away to get Medicaid because I did not know I would need it.
Right.
So there are kind of arguments like that. Like, I didn't have that medical condition at the time that I did this action. So
Right.
those are ways to kind of push back if you do get a penalty, if you can provide evidence that your medical condition and issue happened after the transfer, so you didn't transfer it to become eligible.
Right.
And that makes sense.
Yeah. And so there's a lot of issues with, like, if you put all of your money into an annuity or into a trust, there's specific trusts that can be allowed in certain circumstances, but they're all really complicated rules that you need to talk to an attorney that does Medicaid planning for, to make sure you do it in the correct way. That is, I would not call our helpline for advice on that issue outside of maybe do I have the kind of resources where I should spend them? But I would talk to an estate planning attorney who does Medicaid planning, because they will know the documents that you can and cannot create, the ones that will cause problems for you, because even though you can't access the money, it still creates a penalty. So in general, the rule is, do not give anything away for less than fair market value unless it's to your spouse. If you have done it and it gets returned to you, it can get rid of the penalty. So if you did give something and then they assess a penalty and the person you gave it to is willing to give it back, you would then have to spend it on your care before you became eligible, but you wouldn't have a penalty.
Okay.
And the penalties are kind of confusing. The way it works is that the exact cost of your penalty is how much of your nursing home bill they will not pay. So if you gave away $10,000, they will not pay $10,000 of your nursing home bill of their portion of it. So you would have to pay your portion, and you would accrue a debt that you would have to figure out how to pay off up to that $10,000. And then once you reach that amount, then Medicaid would start paying. It's essentially saying, like, you had assets available to pay your bill, and you gave them away, so we're not going to pay that part of the bill because you shouldn't have given those away.
I find it interesting that they have these intricacies when it comes to counterbalance and balance and so on like that, but yet they can't provide quality care in these nursing facilities. And you made a statement, you said, you know, nursing facilities are expensive. And that's very true. I guess when we're looking at where the money is really actually going, because the big question in neon lights is whether is it going to quality care? Should we be looking at the salaries of vice presidents and companies that purchase these nursing facilities that are very wealthy? I don't know if that's something the federal government would even, or is even looking into, or even state, but the point is there's this imbalance so extreme. And when you hear of all the intricacies that are involved when it comes to qualifying for Medicaid and for assistance and for proper offsetting of payment for the nursing facilities, you just can't fathom the fact that there's a question now that we're having with quality of care, because it seems like they have it down to almost a science. When you do this, this happens. If you don't do this, that happens. But quality of care isn't a standard. So I know. Yeah. Sorry, go ahead.
Oh, sorry. I didn't mean to talk over you.
That's okay.
I was going to say that I do know that the Biden administration in 2022 put out sort of a nursing home review that they were starting on, and it did specifically reference private equity firms and the drop in care at those types of facilities, which are the ones that, you know, pay out to shareholders and you know, may take certain actions that reduce the care in the facilities. So that is something being reviewed. I know that they were supposed to put out new nursing home standards at some point, that they're working on them. They did put out new standards for CMS when they're kind of investigating if a nursing home is doing enough. And that came out in October of 2022. So that's, there's like an appendix PP is what it's called, but it's for the actual inspectors who go into facilities to evaluate all of these standards and to figure out when they're not meeting them and how best to figure that out. So there have been changes, you know, sometimes with those kinds of changes, it takes a while to see the impact of them, but it is something that's being reviewed at the national level. And I know there's a lot of national advocates that are pushing for broader nursing home reform, whether that's, like we talked about earlier, more home care options, or, you know, limiting the corporate ownership in certain circumstances, or wage pass-throughs to staff so that you keep good staff at facilities and you don't have this treatment of the nurses and the CNAs that really pushes them to leave the industry. So there's a lot of quality problems. I agree with you that I have, you know, I'm not a economics major. I'm not like somebody that investigates the exact finances. Like if you give me the finances of a corporation, I'm like, oh, this is a lot of numbers. But there certainly is a lot of Medicaid money going into facilities. And in my opinion, if you are taking federal tax, provide a service, then you should be providing an adequate and good service.
Exactly.
And that's the standard, is that an adequate service is that they need to be doing that. So,
but also accountability, the accountability factor to making sure that they are doing that, even with Biden doing what he's done in terms of the nursing home reform. There has to be that we've fallen short of accountability. Our inspectors have fallen short of accountability. Our state government has fallen short of holding these nursing facilities accountable. So again, like you said, I mean, neither am I an economics major, but I've walked the path of being on the ground in the facility, and not for a few months, a few years. And I've seen it. So it's just a serious imbalance. So I'm glad that we have the things in place, like you were saying, with the qualifications and the protocols, and they all have their place. And I hope they continue to review them to make it better. Like I think you said something very pivotal, and I really would like to run with it. um, after is the fact that let's make staying at home the rule and going to the nursing facility the exception. I think that is key. I
Mhm.
think that would really be effective to turning things around, um, all the way around, I think.
Yeah, and there also are, other models of care that have been considered like facilities that are like cohorted. So it's more like a group home where you have less people being cared for by, one direct staff person who's responsible for these 4 people versus somebody responsible for an entire wing of a nursing home.
Right.
And also, that can reduce transmission between patients because you're not having somebody kind of going back and forth between these places. So there are a lot of ideas of ways to improve the system. I think what we all agree is that it's not doing what it needs to be doing at this point, and it sort of needs to be an all hands on deck. Every
Yeah.
part of it needs to be fixed, and we need to think of all the creative solutions as well as all of the practical, immediate solutions that we can implement. So it's kind of both, right? Like,
I agree. Like, I think, we could all make everything look good on paper and we can sound good when we talk about it, right?
Yeah.
But
Yeah.
who's about the business of actually getting it done?
mhm,
That's the question, because the fruit of what is happening is what we're seeing now, that it all looks good on paper. It always
mhm,
does.
yeah.
But actually marching it out is that's when we'll see the results of it. So
Yeah, I hope there's I mean, I appreciate the work you guys have done on it and continuing to get individual people interested in this issue, as well as kind of supporting the national efforts where they exist, because I think there are groups like Justice and Aging and Help, which I don't know the longer term for them,
mhm.
that do work to try to get nursing home reform and home care reform. And so just, when they're calling for support, just making sure we're all like raising our voices to say, yes, we agree with them. Yes, this is a better system. Yes, this is, an immediate necessity to address this ongoing decades and decades and decades long problem that
Exactly.
we keep
Exactly.
I kind of joke that I'm just trying to make it fixed before I get there. I would much prefer that it be fixed long before I get there, but I mean, to me, it feels like because it's been such a long period of trying to make some of these improvements that we just have to keep pushing as much as we can in whatever kind of places that we can push to make even incremental adjustments.
Well, see, that's the thing. All the things are in place. All the pieces are in place. It's just that there's no one to hold anybody accountable, or no one's willing to hold anybody accountable to make sure that those pieces stay in place or that those pieces are enforced at all.
I know.
Because when I worked the profession, yeah, everything looked great on paper, but as long as nobody checked that paper.
Right. I know that one of the Biden administration pieces was to make the like rating system and information about nursing home problems more accessible to the public. So if you were trying to figure out where should my loved one go, you would actually have an adequate resource that would explain kind of what are the problems with this facility so that people can make better informed choices. That itself is not a solution because we don't want anyone to be somewhere that's not providing good care, but it is, again, one of those pieces of giving the consumer and the individual information so that they can make the right choice. Because I think it's very overwhelming when you're in a crisis situation to figure out, like, is this the place that someone I care about should be or not? Like, how do I know?
Yeah.
So those are kind of smaller changes too that I think are very important.
Yes.
Sorry to switch back to resources. I feel like I
Go
just keep
ahead.
bouncing.
Go ahead.
Let me get back to my outline.
Yes.
Which is very good because I think when you talk about Medicaid requirements straight through, it gets to be the slog of information. And so I'm glad it's more broken up in this conversation, but hopefully it still kind of all makes sense. But I just wanted to return to the fact that if you have $2,000 worth of assets you're allowed to keep, there are certain things that are exempt from that. So like one car, you don't have to say what's the equity value of this one car I own. That can be exempt and not included in your assets. The furnishings and belongings in your house aren't counted. If you live in the home, so if you're on home care, your house isn't counted so long as the equity value is under $688,000. And so that means the amount you paid off. So if you have like a very high mortgage and your equity is very low, you only have $100,000 in equity, but it's a $800,000 house, that's not the exclusion. It's basically if you have so much money in your house, we're saying that you don't qualify for Medicaid on that basis.
That's for home care?
That's for home care, or if you are in the nursing home and a family member qualifies to keep the house. Because if you're in your nursing home and no one's living there and no one is eligible to keep it under nursing home rules, you would have to sell the house, because you can't just like have a house you own while you're in the nursing home for the rest of your life.
Let me just pause there a second, because I distinctly remember there were quite a few family members that had spoken to us with regard to this specific issue. One, that they had to sell. This is a daughter that said they had to sell their mother's house to pay for the nursing facility, or they had to give it up in order to qualify for Medicaid. So what I'm understanding by what you're saying is that her mother could have, in effect, passed that house on to her as her daughter. Is that what I'm hearing?
No. There are certain children who could keep the house. So if they were a disabled child under Social Security rules, they might be able to. Or if they provided care for a certain period of time that kept the person from needing nursing home care, they might be able to transfer the house. But in general, if you're within that 5-year look back, you can't just give the house away. It's only if like a certain qualified person is living there, or a spouse. Obviously, you could give the house to a spouse, but otherwise you would be required to sell it. In most circumstances, outside of having like a qualified family member that lives there, or that you're able to transfer it to, or like I said, the care provision if they provided. And I don't have the exact requirements on that, but there's like specific rules on how much care you would have had to provide in order to receive the house. Essentially saying like the state would have had to pay this amount in Medicaid bills anyway, and so we're going to allow the transfer because it kept this person off of like a higher level of care for a period of time. But but otherwise, yes, you do have to sell it unless you're planning to return within 6 months. So if you go in for a shorter stay and you know that you'll be out within 6 months, you don't have to sell it at that point. Or like I said, if the person living in it is somebody that qualifies to be able to stay living in it and keep it as an exempt resource for that period of time. Or in certain circumstances, you can transfer it to like the spouse or maybe a disabled child.
Okay.
There's also sometimes rules if it's jointly owned with other people, and those rules depend on your category of Medicaid. So some of the stuff is very hard to go into on a kind of like a broad rule basis because it's so fact specific.
Okay, I understand.
But they are not incorrect. They most likely did have to sell the house.
She did.
Yeah, most likely.
She had to sell the house, and she didn't live with her mom, but she took care of her mom while she was in the house. You know, she went there every day and took care of her. But in order for her and her siblings to have her mom qualify for Medicaid, she had to sell it, they said.
Yeah, I mean, I'd have to look at the exact rules to see if they would meet any individual exception, but that sounds like that was probably correct under the rules. And one of the important things for me to say about Medicaid rules, it's not that I agree with them, it's just what they are, which I would always tell my clients when they'd be like, well, why do I have to do this? Like, you know, this is so upsetting. I think personally, the requirement to sell a family home is a really harsh one to many people because it's very important to parents who have paid this house off, who have wanted to give it to their children. It's a accumulation of wealth and a way to help their family, you know, do better in the future. And I think it's a pretty devastating rule in the Medicaid program that is very, very upsetting to people. And, you know, where possible, we try to help people figure out if there is a way to transfer it that's allowed. But sometimes that's, you know, the program rules are what they are, and they end up with fairly harsh circumstances for people that go against what I think we should be trying to do.
Yeah, I think that is it is hard for people who all that have worked like that for that all their lives, for their home and things like that, and then to have to, when they get older and need someone to care for them, they have to give it away, or, sell it.
Mm-hmm. Yeah, I agree. And I think, there's been some Justice and Aging and other national groups that have been looking at sort of the equity issue of these rules. So the ways in which that this disadvantages low-income people and families of color, and how this generational wealth isn't able to form because you take one of the largest pieces of inheritance that most people give to their kids away in these circumstances. So I know there has been, national review of the issue and pushes at the national level to change it. So this isn't a Virginia rule. This is a Medicaid federal program rule.
Okay.
So that's, and in some ways, our rule is more generous than some other states are on this issue. So there are, parts of the Medicaid home distribution rule in Virginia that are more generous than they might be in another state. But it's one of those things that has to be changed at the federal level because it's a federal rule about the home.
Okay.
So, and then kind of the big last thing I want to get to is like the buzzword that's been in all the newspapers, and you guys have probably seen everywhere about Medicaid unwinding. So I want to at least like touch base on it and talk about it.
Please do.
Okay. The first thing is what's happening is we're reinstating the practice that always existed before the pandemic of reviewing everyone's Medicaid case once a year. So Medicaid unwinding is restarting the yearly redetermination process where you have to confirm that your income still qualifies, your assets still qualify, you still meet those 9 financial criteria. And so it's just a shock because many people have never gone through one before because they got Medicaid after 2019. And even the local offices, many of their employees have never done it before because they started after the 2020 pandemic rules were put in place. And so a lot of the concerns around it are essentially that people won't know it's coming, won't respond to the documents in time, and then maybe the local offices won't have sufficient training to kind of spot the issues, especially in the first couple months where it's the first time they've ever done it. So those are kind of the complicating factors, is sort of ignorance on both sides about how this might be done. The state's done a lot of work to try to get information into the caseworkers' hands and provide training and provide sort of assistance to correct issues as they come up, but that's kind of the concern. And so the implementation, it already started. So it started in March of 2023, and it started with something called an ex parte process, which is where they try to renew as many people as possible without talking to them. So if possible, so if you don't own any assets and they can verify your income through their computer systems, they will just automatically renew you for a year so that you don't have to do anything. That's their goal, as many people as they can. They want to automatically renew because it requires less paperwork, less employee time, and if they're already eligible, then they're already eligible, and we don't need to, waste our time doing something we can confirm. So those have already started. They get back, once they find out who they can't ex parte renew, they have to send a renewal package to them. And you have 30 days from the receipt of that package to turn in whatever they've asked you for. So you have to fill out the paperwork that they send you. If there's any required documents, you would send those with it and you would return it. If you return it and they say, well, we also need this, they might send you a request for more information, respond to that request. So anything you get in writing, respond to. But if you don't, you get the renewal package and you don't turn it in, your case will be terminated at the end of that 30-day period. But you have an additional 90 days to send it back in. And if you send everything they need, they'll reopen your case back all the way to your termination date. So it's kind of like...
Sorry, I didn't mean to cut you off, but I just wonder, can they call Virginia Poverty Law Center to help with that packet in terms of filling it out and so on like that?
I think we help with Enroll Virginia, and so they can call the senior helpline if they have questions about something individual, or they can call Enroll Virginia if they have questions about it. I don't think that the senior helpline has the capacity to help an individual person like fill the form out. But if you're like, I don't know what this means, we can help you try to figure out sort of what that question means. You can also try reaching out to the ombudsman to see if they have assistance, or possibly the social worker at the facility. If you have a good social worker, could help you with it. They would be familiar with the process if they've been in the industry for long enough, because they would have done these in the past. And they're not like a new thing that's different. It's just kind of reinstating the prior system.
Okay.
And so even if they review you and you're not qualified for your same level of coverage, they have to evaluate if you're qualified for a different coverage now. So before terminating you, if you're, you don't qualify for this type of Medicaid, but you do qualify for this other kind, they can switch you into a different category. And then they have to send you a notice telling you that there's been a change. And so every notice you get, if you get a notice terminating your Medicaid, you get a notice that there's a reduction or a change, all of those have those appeal rights we were talking about earlier, where you can say you think they made a mistake and go to a hearing and provide evidence that it was done incorrectly. So in addition to that extra 90 days to send it in, starting from the same initial termination date, you have 30 days to appeal, but you have to appeal immediately within 10 days if you want to keep your benefits. So if Medicaid's paying for something, you have that 10-day window to appeal to keep them paying for your things.
Okay, that's what I was going to ask the question. Okay, yeah.
Yeah.
While you're going through all this, they would still, while you're going through the appeal process, they would continue, but only until there's a determination?
Yes.
Okay.
And if you, so long as you appeal within that 10-day period before they're terminated, because they have to give you advance notice that you will lose a benefit. And if you appeal before the date where you would lose it, you can keep it during that time. During the pandemic, all appeals included keeping your benefits no matter what. And during the pandemic, you didn't have to pay back if you lose. But post-pandemic, you might have to, if you keep your benefits and then ultimately lose, you could have to pay that back to the state because you were receiving a benefit you were not entitled to. So that's something for someone to consider when making the decision on whether or not to maintain benefits. And even if when you initially apply, you ask to maintain your benefits, you could later on ask them to stop them if you think that, okay, I don't think I'm going to win this. And so from the date that you ask them to stop it, they shouldn't keep them going and charge you for those. So that's the consideration is, how likely am I going to win? Am I worried that I would have to owe some of this back if I lost? So, and it's not all going to happen like in the first month. Renewals are going to happen for a 12 to 14 month period, meaning that, somebody listening to this, their family member may not get a renewal until like February of 2024. And so you may be waiting and waiting for the documentation and it's not coming. And that's because they tried to separate people out evenly throughout the 12-month period, because every year you have to do the renewal. So that if they did everyone in the first month, then every year they would have to do everyone in that first month. And they don't want that to happen. So they spread everybody out throughout the year. And then in future years, you'd be around that same time that you would do your redetermination again. And so, yeah, so it's spread out, which also makes it confusing because we can't say like, oh, you'll definitely hear from them by June 1st.
Right.
No, you might hear from them in March of 2024. April 2024 is the last month that they're technically doing renewals with, paperwork coming in after that and things like that. But sort of the last batch would be April 2024. But you want to make sure that if you change address or phone number or any contact information since 2019 or moving forwards, that you let Medicaid know and you let your MCO know, which is your managed care organization, which most people will be moving to Cardinal Care at some point in the future. It'll just be one MCO rather than two like we previously had. But you just want to update contact information with them so you receive the notices, because it's hard to respond to something you haven't received. So just making sure they have you move or you change anything, just making sure you update that so that you get it when it comes out.
Okay. Wow.
Yeah. If some people will lose Medicaid correctly. They've been kept on because we haven't been reviewing things. They've gotten a new job. They've inherited, someone's passed away. They've had an inheritance. Their retirement started and it pays them a lot of income they previously didn't have. There are reasons why people are no longer eligible correctly. And so those people either maybe have a different insurance or can apply for marketplace insurance. And there's a special enrollment period, so you can apply up through July of 2024. There's not just like a period of the year you can apply all year long. So if you lose your Medicaid, but you need regular health insurance, you can apply for marketplace. And there are government subsidies if you're low income. So if you're above Medicaid, but you still are fairly low income, you might qualify for a subsidy that helps pay for your insurance, so you don't have to pay as much out of pocket. So that's something you can call Enroll Virginia for assistance with evaluating and applying for if you lose Medicaid correctly. The thing we're concerned about is people who lose it because they didn't file the paperwork, or they tried to file it, but Medicaid lost the paperwork, or all the administrative errors that might happen. And so those people have the 90 days to submit things late, as well as that 30-day appeal timeline. And if you miss both of those, you can reapply. So there's always kind of
There's an option.
Yeah, if you're at day 95, you can reapply and ask for 3 months of backdating, and that would still cover those 3 months that you didn't have care. But you can only get 3 months of backdating. But that's, yeah. So much information about it. And there is some kind of long-term care specific protections that are good. The first is that Virginia has chosen to ask for a waiver so that they do not have to look at accumulated assets during the pandemic for long-term care recipients. So specifically, if they haven't changed your patient pay for the last 3 years, so if your family member went from home care where they kept $1,400 a month to nursing home where they're only supposed to get $40, they've actually been getting $1,400 a month in the nursing home. And so that will have accumulated in their bank account if they haven't been spending it. And so when they did a redetermination, those people would have lost coverage immediately because they had accumulated all these assets.
Right.
So instead, what they've asked the federal government is that they can not look at that for a 12-month period after the redetermination. So if you get your REDI in April of 2023, and you have $12,000 worth of assets that have come from them not changing your patient pay, you will still get Medicaid through 2024. And then at that point, you have to be back down to the $2,000. So you get an extra 12 months to reduce those resources and spend them on allowable things before you would lose Medicaid. So that's a really good long-term care protection that is maybe going to be complicated for them to enact, but is what they've said that they plan to do. And so as far as like, what can I spend that money on in the 12 months after redetermination? They put out a FAQ that has a kind of a pretty big list, but it includes things like, buying a television for that person. So you can't buy it for yourself if you're the family member. You would be buying it for the individual on Medicaid with their own money. Repairs or renovations to that person, home, burial items or other items that are exempt, vehicles for personal use, paying for a year of haircuts ahead of time, paying for food that's outside of the facility to come into the facility, buying Depends, buying hearing aids, buying glasses, buying anything that's for that person. That person wants to go on a vacation, spending that money on them for their vacation. You should not spend it on yourself as the POA or the caregiver, but if you're spending it on that individual person, you are allowed to do so. You just have to keep receipts of how it was spent so you can show that it was spent on them. So that's like a very good rule that Virginia has chosen to do. So it's not something we were required to do. We've chosen to do that in order to keep people on their long-term care for nursing homes. And I think in part because nursing homes haven't known, how to advise people on what to do with any of this money or changes. And so they've often been telling people not to spend the money in case. And so Virginia is saying, well, they should have been able to spend it the whole time, but we'll give them an extra year and we'll explain that they're allowed to spend it on these reasons during that year period. So to sort of address the fact that many people may have been told to keep the money. And
that's interesting.
Yeah, the other big one is that, if anybody has the stimulus check still, I know it wasn't that much money, the 3 stimulus checks, but if it went into someone's nursing home resident account and it's just sat there, that money will be excluded, should be excluded forever. So there should be no point in which that is counted as part of your $2,000 of assets. So if somebody gets kicked off Medicaid for having $4,000 and they can show that some of that money came from the stimulus check, that should not be considered as part of their $2,000. They should just be allowed to keep it because it's disaster assistance. And disaster assistance is excluded from consideration in means tested programs, which is what Medicaid is. So that's like a real specific kind of weird rule. But if I think a lot of nursing home residents, especially if they don't have family helping them, may still have those amounts and they should be excluded. So if that's you're getting kicked off of Medicaid for having $3,000 in assets and 1,000 of it was stimulus check, then you should make that argument to Medicaid and provide proof of the deposit that it was from the stimulus check, and it should be discounted.
So I'm thinking of people who are residents that don't have an advocate or someone who can speak up for them with regard to this.
Mm-hmm.
I wonder what happens in those situations when it comes to, say, for instance, the scenario you just gave with somebody that got the stimulus check and it went into their account and they've got like $4,000 sitting in there, but
Mm-hmm.
they're incapacitated in terms of the fact that they're not able to advocate for themselves.
Yeah, so the ombudsman should be able to help some people who maybe don't have family or an attorney or someone to help them. They're aware of this rule and they have
the nursing school, the nursing facility would alert the ombudsman concerning? Who would alert the ombudsman about that?
Yeah, it might be the nursing facility if they get a denial and they need this person to have assistance appealing it, they might reach out. And also the nursing facilities are supposed to be getting a lot of this information as well about what should and shouldn't count. So they themselves may see this and say, I mean, they want their residents to qualify. They want to be paid. They don't want gaps in service where the person isn't able to pay them. And so there is some incentive for them to try to get these issues corrected where there's an obvious error. So it just depends probably on the individual facility,
Mm-hmm.
How aware they're going to be of all this guidance. I mean, it's so much guidance. It's so hard to kind of, Medicaid by itself is so complicated. And then you add all of these rules and changes, it's reasonable that somebody is going to miss something. But I think, so long as you're, as long as they're trying, hopefully they'll at least reach out to kind of ask the question, like, I thought this wasn't supposed to be counted. That's what's in this account. So shouldn't it be excluded? They may be the one in certain circumstances to help as well.
So the reason why I kind of chuckled just now is because, again, with my mom's instance, the facility, the office, they were actually taking money out of my mom's account.
Mm-hmm.
And that, that just came up illegally, I should say, fraudulently. That came up in an investigation by the Virginia Department of Health, the licensure division. So when you look at the dynamics of those possibilities,
Yeah.
it's just,
like I said, the good facilities will hopefully be helping people.
Yeah, the ones who are doing their due diligence, those
Mm-hmm.
ones. Okay.
Yeah. And I can't, there are going to be people where incorrect decisions are made and things are calculated wrong. And then that money is going to be paid to the facility where it shouldn't be. And we all know that will happen. Our goal is just to try to have it happen as little as possible because, especially as people who have had family members in facilities, I have, and you guys have both spoken about personal experiences, but they lose everything in a facility, they lose the glasses, they lose your favorite sweater. So maybe just spending some of that money to buy 6 extra pairs of glasses. So every time they lose the glasses, you can bring a new one in, or, multiple of this favorite sweater so that it shrinks in the wash, but you have another one.
Mm-hmm.
Some of these things, just using this stimulus check money and any accumulated assets to buy things like that. So to try to counterbalance some of the just, realities of what happens in facilities, often not through, sometimes I feel like it sounds like I'm defending facilities. Sometimes, there is malicious actions and individual staff are, taking money, stealing, purposely harassing people. That obviously happens. People are people, and there's always people that act poorly in every industry.
Yeah.
But a lot of it happens unintentionally or, just through lack of care or just having like a system that is trying to deal with all people's possessions equally, which means that all sweaters go through the same dryer and it shrinks everything. You know, whatever the thing is, some of it's intentional, some of it's not, but just you can use some of this money to purchase things that the person needs. So before the redetermination happens, you can do it. And then after, they're going to redetermine you as of the month that you are being evaluated. So that's the month you need your resources to be reviewed at and your income reviewed at. But for those long-term care people, unlike everyone else, and by long-term care, I mean nursing home and home care, you get that additional 12 months to spend down those assets that have accumulated from your patient pay not being adjusted.
Yeah.
If you've accumulated assets in a different way, so you inherited something, whatever else, you got a retirement account that was somebody else's, you became the beneficiary of, whatever other reason why you now have assets, those are not treated the same as something that's been accumulated because of the patient pay.
Mm.
So you would lose Medicaid for those. So if you inherited $100,000 from somebody, you would end up off of Medicaid until you had reduced that $100,000 back down to the $2,000. What we're talking about is someone where every month your patient pay was incorrect. And so slowly over time, it built up to this much larger asset amount because they didn't recalculate it.
Right. Okay.
And so that's something that Medicaid should, or DMAS and the DSSs are trying to figure out how to kind of evaluate those and do them correctly. But if you think that if you think they've done it incorrectly, again, it's probably an appealable issue. If they've determined something was an inheritance and it was actually the patient pay adjustments not happening.
Yeah, it's, oh my gosh.
Yeah, it's complicated, and we're trying to create some simplified resources that will be on our website. They aren't at this time just because there's still guidance and documentation coming out from the state and from the federal government on it as they start to see issues arise and they try to address them. And so we're trying to create sort of simple documents explaining some of this. But again, if you end up in a complex issue and you need to call us, we can see if it's something we can advise on or kind of redirect you to someone that can help.
Has the Elder Justice Initiative that Biden put in place, has that been something that the Virginia Poverty Law Center has been reviewing? And how do you see it being effective here in Virginia?
Is it not the nursing home one? Is it a different?
Yeah, it's the initiative where they're supposed to be reviewing and taking a second look or a better look, in-depth look at nursing facilities and how they're operating, how residents are being taken care of or the lack thereof, et cetera.
Yeah, so I know that we have submitted comments on various regulatory changes. So the Biden administration has changed a lot of Medicare rules to make things better for people. So that's more like rehab services versus long-term care. And so our involvement is primarily through national partner agencies who do the direct lobbying, and then they may reach out and say, will people comment on this and talk about how it happens in Virginia? And so we have submitted, essentially comments are where you say, yes, this rule should change. We see all of these problems, this rule change would benefit, or, the rule should change, but you also need to fix this part of it that you're not addressing, or we don't think this rule should change, it's really good, right? So you lay out to the federal government the arguments of, why this is a good or bad change in policy, and then you can submit it. So we do a lot of that, of reviewing CMS and other agency policy changes to say that we think they're an improvement or a harm. And I may be a little bit behind on the Elder Justice Initiative for nursing homes. I am not aware of sort of the final guidance, kind of final rulemaking happening. I know that they just did a rule on Medicare Advantage appeals of nursing home issues to try to improve that process, because the Medicare Advantage programs were denying a lot of people. And so they were trying to strengthen those rules so that it was harder to incorrectly deny people for rehab services in a nursing home. So there's been a lot of sort of like bits and pieces of reform that are trying to address specific individual problems. Whereas I think that sort of the larger nursing home reform portion is still under consideration and hasn't kind of come out with the policy on that yet, is my understanding. Unless you're aware of me, I'm a little behind.
Okay. Yeah, I mean, you answered, and that's very good. I've been reading quite a bit about it, and actually have been referring a lot of family members to it. Also the Justice Department itself, because they are inviting people to write in and to let them know really what's going on the ground. I just don't know what follows behind that. Really, I'm not too clear. Once that's submitted, what follows behind that. So, that remains to be seen. But at least it's an opening, and we have been encouraging family members to please, please, please send in your stories. Let them know what's happening. And we, as far as we know, that there have been family members doing that. And not only here in Virginia, we've also, as we get a lot of calls from different parts of the United States, we've also been telling them the same thing. Because like you said, each state, is different. And, in a lot of ways here in Virginia is not as bad as some other states that we've seen. But, we all agree it's a national problem. It's a big national problem, the situation with nursing facilities. Medicaid across the board, I think, really should be more considerate of a lot of things that kind of just went by the wayside. I can appreciate that they're now trying to, take little bits and pieces of looking at it and trying to fix this and so on. But like you said, it's going to take time, isn't it? And what we're trying to do is to not lose lives because of the timing, and also because of, all the dynamics of the suffering that's going on from the family, with the family that has to endure the journey. So I think the Virginia Public Law Center is one of the key pillars that'll be able to at least give them some comfort in knowing that's an option that they have to be able to reach out. I know that the legal aid, I'm familiar with legal aid to a degree, and I think that's also something that, is worth mentioning and putting out there, because a lot of times people go to attorneys, and like you say, they're very expensive, and they come with, our experience going to attorneys has not been good, because, we did a podcast earlier with an attorney that really explained the back end of things that's happening, how it happens, why it happens, and why people are walking away from trying to get justice for what happened in a nursing facility, disappointed. And so it really does give us a feeling like, there's a ceiling that you hit and you can't go any further. Your center, I think, gives them the option of knowing, okay, well, here's an opening where we can go ahead and see what we can do, or get some help, or at least have somebody to talk to that can help advise them.
Exactly.
I think one of the, and I previously worked in Illinois, which is also a bad nursing home state. So similar to you, have walked through many facilities, and it's always when I stick to the floor is the first indication that this isn't a place to come to. You walk off the entry mat and you're like, oh no, I'm sticking to this floor. So this is not a good place. But thinking about it in that context, it obviously depends on the individual legal aid office. They all get different funding from each other. So one legal aid office may not get funding to do certain kinds of cases, and another one might. And so it's just hard to tell you, this one will definitely take this case, this one will not, but it's, worth your time to reach out to them. One of the things that I really, because they will tell you, we don't do that kind of work. We think you might have a good case, but we can't help you. Here's how you'd file an appeal on your own. Here's what you should argue. They might be able to give you some information even if they don't have the resources to take your case. But if they do take your case, one of the things that, as a legal aid attorney, when I did direct services, that was one of my favorite things, is you didn't have that same, my clients run out of money, they have a good case, but it doesn't make sense for them to keep pursuing this because they can't afford to pay me to do it. So instead, what we were doing was, evaluating what's the right answer for this individual case, and do we have the resources to keep pursuing it ourselves without having to make a determination on if, someone could pay to have kind of that justice. But it does also, there are also types of cases legal aid doesn't take, like they do not do cases with personal injuries in a nursing home. So if that's a kind of case you want to take in general, that's not something legal aid does because of the way their funding structured, where they're not supposed to do cases that have attorney fees built in unless an attorney won't take it. So maybe in certain circumstances they would do it, but primarily that's not, wrongful death and personal injury are not going to be legal aid cases. But if you have a Medicaid issue or a nursing home discharge issue, or not enough care hours for home care, these are things that could be something that legal aid would assist with. It would just depend on the individual legal aid.
Okay. Well,
So much information. Sorry that
I think it's rich. I really do. I think it's very rich. And I also appreciate the fact that you explained it very well. And definitely given me a lot to think about, even in the organization, because we want to make sure that we are helping people understand that they do have one, options, and two, understand the protocols and the laws and the requirements, and be able to navigate them with knowledge. And that's why we do these podcasts, because we just want people to know, and not be like how I know when I was just like nothing. I knew nothing. And so I was learning as I went along, and it was daunting. It was very daunting and disappointing and hurtful. And I think that the more people know, the better the more equipped, or the better equipped they are to stand up and say, hey, no, that's not right. And they have a legal leg to stand on. So I want to
And
tell you.
that's one.
Go ahead, Tracy.
Oh no, I was just gonna say, and that's one of the things that I know in my experience, it's true. When you don't know, I mean, I thought going to an attorney, if you had a neglect case, that it would be, it was like a one shot, but it's not, because there are so many things that you don't know when you go to an attorney, like the 2-year statute of limitations. I didn't know that. I didn't know that you had 2 years, and then after that, an attorney wouldn't touch it. So a lot of families don't know things. So the information that you're given is awesome.
Yeah. As far as timelines, just remember that if you get an adverse action, you have 10 days to appeal and keep benefits, 30 days to appeal total, but you still have those 90 days to turn things in for renewal packages when we get to unwinding. So there are a lot of time frames on notices. So just make sure you read your notice closely for the time periods and try to follow them, because if you miss them, you have to have good cause for missing them, which could be like you were sick in a hospital, or they mailed it to the wrong place, or you tried to appeal but you sent it to the wrong office. There could be reasons that you can get extensions, but it's if possible, similar to the statute of limitations, everything is about doing it in a timely fashion. And I, a person who in my individual life am very bad at opening my own mail, highly recommend opening and reading all mail from DMAS or DSS or any state agency as soon as possible, or from your MCO, just because those timeframes are very specific. And if you miss them, you can always reapply, but you may not. You may end up with a period where it's not paid for, and there's an outstanding balance. So I hate mail. I hate opening it, but please do open your mail and read it, because it is, the timeframes are very strict. And so that's the most important thing, is to meet those.
Well, I can tell you, Emily, we really appreciate you coming on today. And obviously we're going to be in touch, and we appreciate your wealth of information. So by all means, let it begin. Everybody will hear this and they will gain knowledge and hopefully walk forward, better, more equipped than before they started watching this podcast. And see, I told you that it can really go longer than an hour.
Yeah, well, that was, I was like, once you get me into Medicaid rules, there's always an
always-
exception, and there's
yeah.
always, you know, another argument. That's important to know too. There's always an exception with Medicaid rules. Not always, but often. So
investigate it to see.
to investigate it to see.
Yeah, yeah. Thanks a lot, Emily. We appreciate
so
you
much.
coming on, and we will definitely be in touch with you. And everybody, I hope that you take advantage of the information that you've gained today, because it is a wealth of information. It's beneficial to you, and it's definitely given me more to think about. And of course, if you need to reach out to our organization, feel free to do that. You can reach out to the Virginia Poverty Law Organization and Legal Aid. Those are tools that you have in your belt that you can use. So hopefully you enjoyed our podcast today, and we will see you next time.